Video 7, Supreme Court Error. I'm Rick Nichols. I wrote the book titled Make America Financially Great. The book is based on 15 years of research that included the 1913 Federal Reserve Act and the 1864 National Currency Act. One of the questions I had was, who said the Federal Reserve Act is constitutional? The answer is Chief Justice Marshall in the 1819 Supreme Court case McCulloch v. Maryland. Justice Marshall ruled that Congress may use a government-sponsored corporation as a means, a tool, to accomplish its constitutional responsibilities. That case set the legal precedent that is used today to rule that Congress may delegate its constitutional decision-making responsibilities to the Federal Reserve banks as privately owned for-profit corporations. 5 years later, Justice Marshall showed his error in the 1824 Supreme Court case Bank of the United States v. Planters Bank of Georgia. Justice Marshall said that Congress had no power to control the decisions made by the non-government people who control the First Bank of the United States Corporation. Justice Marshall said that Congress is demoted to the level of a simple stockholder. Technically speaking, that means Congress can't use a government-sponsored corporation to fulfill its constitutional responsibilities because Congress had no decision-making power over the corporation's board of directors. Therefore, citizens have no representation in corporate decisions. Here is the list of government documents that I studied that led me to see Justice Marshall's error. 1790, Alexander Hamilton's report to Congress on the First Bank of the United States Corporation. 1791, Alexander Hamilton's letter to President Washington explaining that the First Bank of the United States Corporation is constitutional. 1791, an act to incorporate the subscribers to the First Bank of the United States. 1816, an act to incorporate the subscribers to the Second Bank of the United States. 1819, Supreme Court case McCulloch v. Maryland. 1824, Supreme Court case Bank of the United States v. Planters Bank of Georgia. A copy of these documents is in the appendix of my book. It took studying all these documents to determine why a government-sponsored corporation functioning as a central bank is not constitutional. Here's a quick rundown. 1791, Alexander Hamilton's letter to President Washington explaining that the First Bank of the United States Corporation is constitutional. He wrote, "It is not denied that there are implied as well as express powers, and the former are as effectually delegated as the latter, and that a corporation may as well be employed as any instrument of carrying into execution any of the specified powers as any other instrument or means whatever." Which means that even though the U.S. Constitution set up Congress in Article 1, Sections 1 through 7, and then Section 8 specified the expressed powers that Congress is responsible to make decisions on, Hamilton said that Congress may delegate those decision-making powers to a corporation. The problem is that once Section 8 decisions are made by a corporation, then citizens are not represented in those decisions, which means citizens are enslaved to the decisions made by the non-government people with government power. In fact, the 1811 Congress didn't like the decisions made by the non-government people controlling the First Bank of the United States Corporation, so Congress didn't renew the First Bank Corporation and let it die. Then the Second Bank of the United States Corporation was established in 1816. It copied the First Bank of the United States Corporation Act, The second Bank of the United States was also set up as a government-sponsored corporation. And following in the footsteps of the First Bank Act, Congress and President Andrew Jackson didn't like the decisions made by the second bank, so they killed it. In the 1819 Supreme Court case, McCulloch v. Maryland, Justice Marshall agreed with Alexander Hamilton and ruled that Congress may use a government-sponsored corporation as a means, a tool, to fulfill its responsibilities listed in Article 1, Section 8, also known as enumerated responsibilities. Then, in the 1824 Supreme Court case, Second Bank of the United States v. Planters Bank of Georgia, Justice Marshall showed his error by saying that when Congress uses a government-sponsored corporation as a tool, the result is that Congress is demoted to the position of common stockholder. The effect is that Congress relinquishes constitutional decision-making power to the non-government people who make decisions for the government-sponsored corporation. Even though Congress was the one to give government power to the corporation, Congress is treated as a common stockholder with no operational decision-making power. This means that citizens are not represented in the decision-making. Therefore, citizens are enslaved to the decisions made by the government-sponsored corporation. This means that Congress may not use a government-sponsored corporation to fulfill its Article 1, Section 8 decision-making responsibilities. The evidence that Congress has no decision-making power over the corporation is that in order to veto a corporate decision, Congress must sue the government-sponsored corporation in a court of law and win. That is what a common citizen has to do. Congress is no more than a common citizen to the government-sponsored corporation. The government-sponsored corporation's power to sue and be sued means the government-sponsored corporation doesn't have to listen to Congress unless Congress sues the bank and wins. This is the same scam used all the way back to the Bank of England Corporation. Here are some quotes about the power to sue that are included in central bank corporate charters in the past. 1694 Charter of the Corporation of the Bank of England. Sue, implead, defend, or answer, or be sued, impleaded, defended, or answered in any manner of wise. The 1791 Act to incorporate the subscribers to the First Bank of the United States. To sue and be sued, plead and be impleaded, answer and be answered, defend and be defended in courts of record or any other place whatsoever. The 1816 Act to incorporate the subscribers to the Second Bank of the United States, Section 7, sue and be sued, complain and defend in any court of law and equity as fully as natural persons. The 1864 National Currency Act regarding clearinghouses, Section 8, sue and be sued, complain and defend in any court of law and equity as fully as natural persons. 1913 Federal Reserve Act, Section 4.4, General Corporate Powers. Fourth, to sue and be sued, complain and defend in any court of law or equity. And the most recent new central bank charter that I know of is the 2004 Central Bank of Iraq Law. It says the Central Bank of Iraq is a legal entity with the full capacity to enter into contract, to sue, and be sued. It also added a new line. The Central Bank of Iraq shall not take instruction from any other person or entity, including government entities. That means the Central Bank of Iraq Corporation don't take any crap from anybody. The country of Iraq is now enslaved to the decisions made by the Central Bank of Iraq Corporation. In conclusion, today that class of corporation is referred to as a government-sponsored enterprise, which means non-government people get government power. The government power over money is called fiscal responsibilities. The non-government people who make fiscal decisions are referred to as fiscal agents. Our fiscal agents are the Board of Governors of the Federal Reserve System, who are non-government people. Congress and the President of the United States can't stop the non-government people from printing all the money they want as checking account balances. That is reflected in the M3 and M2 money inventory counts. That means citizens are enslaved by the decisions made by the Board of Governors of the Federal Reserve Corporation. That means the Central Bank of the U.S. shall not take bull from any other person, entity, including the United States Congress. Anybody hear of an honorable Supreme Court justice coming to rescue us by saving our representation in enumerated constitutional rights? No? Me neither. Maybe the next Supreme Court judge that's shoved down our throats will be helpful. My book is Make America Financially Great. Thank you for listening to the research of a fellow United States citizen.